not a particularly long session today, a short one just to take you through some parts around the wages. The wages and award changes. We will be recording or are recording this session today, so you can watch back. If other members have missed out and you're aware of that, they can join and look again. But it's just a short session today, just to give you a bit of a heads up on some of the changes. I know a lot of members are already asking for the wages. They are not quite ready yet. So what happens after the Commission makes its decision, which they did almost 2 weeks ago now, well, exactly 2 weeks ago now, they make draft determinations on what the wages and allowance amounts need to be in the awards. They put them out for some comment. That comment on and feedback about if they've missed any decimals or got any numbers incorrect, that feedback's required by this afternoon. So the Commission will then ratify in, bang the gavel, so to speak, on those new wages, and we'll be able to do that. Actually, before I get going much further, I should introduce Anne. Anne Gulliver's joined us in the team. Emma's moved to an internal role now, and Anne's joined us. So she's come in at a great time. Wages, very popular time to be talking to members. They're always calling us up, so that's good. And so she's getting her feet under the desk, so to speak, and head around some of the aspects of our award. Anne's been in HR for quite some years, so she'll no doubt be giving you all kinds of good news that I like to give you. But Anne's just taking a moment to get some of the technical bits around the electrical award and the way the electrical industry operates before she gets fully unleashed on you, or you unleashed on her, whichever way, probably a bit of both. But it's good to have Anne along today as well. She's going to be taking up some of these questions for you soon. So the national minimum wage decision we'll talk about today, and how the allowances and wages will be increased in the award. We'll talk about that. I do expect, the punchline of that is I do expect that they will be available early next week for us to be able to issue out to members. The other two areas that I wanted to have a chat about are the paid family and domestic violence leave provisions. The family and domestic violence leave has existed already, but it's previously been unpaid, and there's an introduction phased for paid family and domestic violence leave. And there's a bit of contention, or a few members have had some questions around this new model annual leave close down clause that the full bench of the Commission has introduced into 70 of the 130 or so awards. So that's had some people confused and a bit worried about what can happen there. There's a whole lot that goes into the Fair Work Commission's decision around the wage increase and their reasons for it, and there's a panel within, an expert panel within the Fair Work Commission that does that. That's all very interesting if you're an academic in the stuff, but if you're a business owner, you really just want to know the numbers part. They've removed, members have said, hey, 8.6 versus 5.75. What's the story there? What's the deal there? The national minimum wage is the amount that's been, or the wage rate that's been increased by the 8.6%. The increase to award rates is the 5.75%. So if you're seeing two different numbers out there and you're confused about why there's different ones, the ones that's going to affect, the electrical award and the clerical award, manufacturing award, those sorts of ones that most would capture just about 100% of our members. The 5.75 is what's being applied there. There's some historical stuff about how the alignment of the C14 and all that sort of good stuff that comes historically, as it looks like they're from 1997, as to how they've increased the national minimum wage. They've decided they're not going to do that anymore, which is interesting in itself, but that's where the 8.6% comes from. The 5.75 is what we'll be mostly focused on, and that's on the award wages. Allowances under the electrical award in particular operate differently. They are typically in a percentage of an award rate, or the allowance will increase by a CPI subgroup, so motor trade or motor vehicle expenses subgroup that the ABS puts out, the Australian Bureau of Statistics puts out. Those CPI indices affect that. Based on what we've seen from the draft determinations, there are some big jumps in some of those expense-related allowances, as you might expect. Given the cost of living pressures, those will also flow through. We will see to those allowance amounts. So you might find things like, the motor vehicle mileage amount, what was previously 91 cents, jumps a little bit based on the drafts. I won't, buzz in with what those answers are just yet, just in case they do change. I won't want to have wrong percentages and figures out there, but just to flag that there's likely to be some big jumps there. One of the common elements or common questions from members around the timing of the increases, it's about the first full pay period on or after 1 July. Another way of describing that is your first pay period without any June wage dates in it or pay dates in it is the first day. So if you do a fortnightly pay cycle, it could well be the 10th or even 14th really of July before you're applying these wage increases. The other increase that's happening at the moment or will happen is the super increase to 11%. That's different. That will be at 1 July. So there will be part pay periods where you need to look at making those increases if it falls within a pay cycle, because it's a strict 1 July effective date. The wages will be effective from the first full pay period on or after that 1 July amount. In most years we see that 1 July mark. There's no difference or phasing or anything that's of relevance to the electrical industry. In past years when we've had the impacts of COVID, we've had some differences in terms of phasing. We're back to sort of business as usual in terms of those timings around when wage increases will happen, and that's that 1 July mark. On the wages summaries and the wages summaries coming in, I know members have contacted us about some issues around 403 errors on the website, that sort of thing. We are fast looking at making sure we can get that up and running so that we don't have those errors. There's some internal website talking to each other stuff that's going on there. Plan A is to get that fixed. We're working on a plan B, C, and D so that when a member wants the wages, we can get to them as fast as humanly possible. So we are aware that there's some website problems at the moment. If there are any questions on the wages and the allowances, or that I can answer around timing and those sorts of things, happy to answer those. If I was out there among the membership and I had an enterprise agreement in place and I was thinking of a good question to ask me, the question might be, how does my enterprise agreement interact with the new minimum wage? You need to increase, or you need to make sure that your minimum rate of pay under your enterprise agreement for that classification, say an apprentice rate of pay for a first year, it needs to be at least what the award rate would be for an all-purpose rate for that apprentice. So if your apprentice rate of pay in your EBA, for example, is $14 an hour, well, you already need to have increased it to 15, 16 now. But if going forward you see an increase that's higher than your rate of pay in your EBA, you will need to match the rate. That's not the case for allowances. Allowances, you can continue to apply your rate. Wages under Section 206 of the Act are required to be met at the award level. So you can't keep your lower rate if it's lower in the EBA. So I'll touch on paid family and domestic violence leave. Now, it's not so much, I guess, an award change as a new type of leave that's coming in, but we're all in the same space when it comes to conditions of employment. As I mentioned earlier, there's been an unpaid provision for family and domestic violence leave. The decision was to introduce paid family and domestic violence leave. It's not from any other accrual type. This is a new type of leave that's payable. It is applicable to part-time and casual employees. There's some eligibility criteria there for casual employees as well, that they need to have accepted the shift for the time and leave is to be taken. So if they didn't have work already, that's not necessarily an entitlement to it there. It is a entitlement that will renew. It's not an accrued from year to year. It's not a per occasion like some others. It will be on every 12 months that it will reset. This is a reset, to be clear. Things like sick leave and annual leave, they don't reset. Family and domestic violence leave will reset every 12 months. A couple of questions just back in the wages area, which I'll happy to cover off. Question around if you're paying above the award rate of pay, is the employer obligated to increase rates of pay? The answer to that is, if your rate of pay is already above the rate that the new award rate, no, you don't need to increase that. These are increases to minimum rates, and it's sort of a subset. And the second question is, just because there's a wage increase of 5.75% to the minimum rate of pay under the awards, it doesn't flow that the employer must increase their rate of pay by 5.75%. That doesn't dictate anything like that. So if I had an electrician, for example, who was on $40 an hour and they came to me saying, hey, I want a wage increase, the employer's within their rights to say, there's no obligation on me to increase your rate of pay, no obligation to increase it by any percent, let alone 5.75%, because you're already well above, the 27.12, which is the minimum rate. And if you would apply just a straight 5.75% to that, or thereabouts, you would still be well within, well above the minimum award rate. So the wage increases apply to the base wages or the wage rates that are applicable in the award. So the base rate will increase. The industry allowance is 3.7% of that base rate, so it will increase as a result of that. The license allowance is 3.6% of the base rate, so it will increase. And the tool allowance is one of those allowances that's adjusted by a CPI subgroup, so it will increase based on the measure that the ABS has identified that as a percentage that has moved for the last period. There's some provisions specifically in the allowances clause as to how those things are addressed or how are increased. So that's how the wages will increase. The reason why I can't give those as a cents and dollars things, not only just as it has not been ratified yet, but those amounts will all be expressed on the wages summaries. We break it all back down, which is again particularly relevant now that we have single touch payroll phase 2. You'll need to update those allowance amounts there in your single touch payroll phase 2 part. So your bookkeepers will be, and then if that's your function in the payroll realm, be pretty excited to be updating those rates again so soon after having publicly implemented them after the extensions that MyOB and Xero got. There's a couple of questions coming in around the family and domestic violence leave, and some around allowances. Also, I'll stick to the wages and allowances stuff just for the moment. The increases will affect the travel allowances, yes. The travel time allowance is one that's impacted by CPI indice, as well as the start and finish on the job allowances are also affected by CPI indice increases. They're not a straight percentage that's already determined in the award. So they will increase, yes, to a particular amount. Again, we want to make sure that amount we're expressing is the ratified rate in the award. So watch that space. In terms of the evidence requirements around paid domestic violence leave. I'll come to that in a moment. There's a question around psychosocial legislation and policies and how to manage psychosocial hazards at work. Yeah, that is a requirement for employers in Queensland. It does exist for other employers in other parts of the state. It's new to Queensland from April. Not a topic I'm covering off here today. I'm sorry, Pip, but it is certainly an obligation for employers. It's a bit of a bridge between, the requirement is both a safety legislation requirement now, which is informed largely by a lot of the IR and HR concepts around, bullying and psychological hazards associated with the way work is managed and implemented, and the pace of which it's done. But we haven't got time today or material to present on that psychosocial stuff. That's certainly something that the safety team and will be involved in. So let's talk a little bit more on the paid family and domestic violence elements. It's accessible from the first day of work potentially, and it's not an accumulation like other leave types where it accrues progressively over the year. And in terms of questions we're having around evidence, that's here for us. So the evidence requirements fall to, in strict terms, Section 107 of the Act around notice and evidence. They're still applicable for things like personal and carers leave that fall out of Section 97. So a reasonable evidence to satisfy a reasonable person is still the standard. Types of evidence might be a bit different. Things like a statutory declaration are common, but documents issued by police or a court or other family domestic violence support service that they're accessing their services are acceptable types of evidence. A medical practitioner might be able to provide some evidence or assistance here, probably less common than obviously in a illness scenario or a carers leave scenario. But there are examples of evidence, and the test is reasonable evidence to satisfy. One of the other elements around evidence here that's important is that there's a separate standard when it comes to privacy here. It still needs to be kept confidential, as would other employment records. There's a higher standard around privacy when it comes to this sort of evidence, if they're providing things like a police statement or police material, particularly if it contains any issues around the claim or the instance. What we would suggest is that the employer has the ability to, or simply cites those documents, and ticks or identifies in their own records that it has cited that evidence, hasn't kept it, and doesn't keep a copy on file. It's not necessary that you keep a copy. It's just about that reasonable evidence to satisfy. And reasonable evidence can be any number of things. There's a question here as well from the wages and allowances question. It's a general question around the tool allowance. Why isn't the tool allowance rolled into why is the tool allowance rolled into the hourly rate as opposed to keeping it separate? In terms of the way the award is structured, there are a number of allowances that are classified as all-purpose allowances. And so I guess the best way to answer this question, albeit a bit long-winded, is to go back to understanding what different types of allowances are. So there are allowances that are special allowance. Special allowance is contingent on the event occurring. The best example of that is, say, the travel time allowance. The work is directed to start and finish on the job site. So it's contingent on the employer issuing that direction. The other types of allowances are all-purpose allowances. Those all-purpose allowances are, as the name suggests, applicable for all purposes in wage calculation of annual leave, sick leave, public holidays, overtime, that sort of thing. It's one of the main challenges that has come out of the single touch payroll phase 2 for electrical contractors, is that it has a number, or 3 key all-purpose allowances. And when it comes to calculating overtime, we need to make sure we're still doing that. So even though reporting wise we're splitting it out, when it comes to actual payment of wages, we need to ensure that tool allowance, for example, the tool allowance is still included in the rate of pay for the purposes of those amounts. So fundamentally, the award describes a number of all-purpose allowance, license, tool, industry, nominee allowance is also one, first aid allowance is also another. The award sets out what the all-purpose allowances are, and for that reason, we need to ensure that it is part of that rate of pay for the purposes of wage calculation and leave payments. So thanks for that one, Amy. In terms of a question around the paid family domestic violence leave, FDV leave, it's a hard one to say. In terms of evidence regarding citing documents, if not keeping a copy, how you record that you've cited that material is largely for the business to determine. So if you want to have a check sheet in the claim form, the leave form, some internal document as to how you have that. It's not a policy position that you need to have out to workers necessarily. It might be a question that workers have, you know, how do you want, I'm worried about sending you this material, I don't want to send it to you. You can have the conversation. I'm happy just to have a look at it if you can show me when you attend work after the fact. And then, yep, cited. You don't even necessarily need to make a record that you've cited it. If it's your payroll function and your business and you've seen it, well, fine, pay the allowance. It's not a requirement as such, it's just a recommendation for the purposes of ensuring that if you're the business owner and you want to check that the evidence is being provided to someone in the appropriate way, having that checkbox there gives the employer the ability to go, well, okay, someone's asked about it, someone's seen it, and maybe they make a note, you know, was a statutory declaration or was a police form or something. You know, that's the extent that you would go to really in terms of citing something. In terms of the applicability of who is family and domestic violence leave available to, that is available to those people experiencing family and domestic violence. I think it would be fair to grab us a nice definition here. The definition of, you know, family and domestic violence hasn't changed, you know, as a result of the introduction of the paid leave component. So it's still, you know, the same thing. But let's go to a definition for the purposes of, you know, when employees can take the leave. It's in relation to someone needing to do something to deal with the impact of family and domestic violence leave, and it is not practical for the person to do that outside of work hours. So that's around making arrangements for their safety or the safety of a close relative, attending court hearings, accessing police services. So the eligibility to paid family domestic violence is the same as unpaid. If it's a child, well, if it's parent and child, they're in the same sort of unit there, and in terms of a family unit. So if it's affecting the parent, then it will be affecting the child as well. In terms of perpetrators, I would suggest by that definition, it doesn't entitle a perpetrator because they're not experiencing it. Appreciate it. There's been some issues in the past. Employers and master electricians have raised as part of the advocacy in this space about establishing a definition. That the entitlement shouldn't extend to perpetrators. The employer is also not in a position to form a view about whether someone is or isn't a perpetrator. So it could be difficult for the employer to determine whether or not that person claiming it is an alleged perpetrator or is the alleged person experiencing the family domestic violence. So there can be some difficulties about establishing that, but it's not designed for perpetrators to be accessing. Tony has a good question around the number of hours days. It's 10 days, and 10 days is based on the ordinary hours that would be worked on that day. So if you're just doing a 7.6 hour day each day, it would be 7.6 hours times 10. Some of our members might be doing other arrangements of hours, 4 8-hour days and a 6-hour day. That would be, whatever. If they claimed a day of family domestic violence leave on an 8-hour day, you're paying 8 hours. If it's a 6-hour day, you're going to pay 6 hours. Thanks for your questions. It's always good to have plenty of questions. It means I haven't bored everyone to sleep within 5 minutes, so that's good. The rate of pay is, and more on that question around rate of pay or how to pay it, it is paid at the full rate of pay, inclusive of allowances. So a common question might be, well, am I going to include things like tool industry license allowance, that sort of stuff, or am I just going to pay this at the base rate of pay? You will pay it at the full, the all-purpose hourly rate of pay. If you have a higher rate of pay because you're choosing to pay $40 an hour or something for an electrician, it would be payable at that rate of pay. You will need a new leave category for this. You also want to keep in mind the confidentiality elements of it. So you won't call it family domestic violence leave as such. You would have it as a special leave type. And just special leave is a perfectly acceptable banner to call it under. And there's some elements there about your timesheet and record keeping there, about ordinary hours and any other payments attached to it, should be as they ordinarily would be for that day. I think the next slide will move on to our topic, probably equally question driving. So I'll hang out just in case there's a few questions feverishly being there. There's a question here. Do we need to have family and domestic violence leave visible as a balance? No, you don't. In fact, a bit of surprise to people often is that the regulations to the Act around payslip requirements and payslip content requirements don't require any leave type to be expressed there. You don't have to include on your payslip that a person has X number of hours of annual leave or sick leave, and certainly for the purposes of family domestic violence leave, it's not a visible balance. It's something that the employer would keep an internal record of with respect to how much time the person has accessed. Thanks for that question. It might be the middle of the year. We might be dreaming of Christmas or panicking because it's the middle of the year and Christmas probably doesn't feel that far away already. But the full bench determined in a number of awards to introduce a new model close down clause. Just by way of a bit of background, the electrical award already had an annual leave close down clause, giving employers the ability to direct with 2 months notice employees that they would be required to take leave at the conclusion at that close down period. The close down period should be no longer than 2 weeks, so no shorter than 2 weeks and no longer than 4. So the full bench has made some changes to that common clause. It's common to about 70 allowances. There's a further question on the family and domestic violence leave. It's not a progressive thing. It is not like those other leave balances. Family and domestic violence leave is just applicable from day one. 10 days the person could access, if eligible, from day one, each 12 months. So it doesn't build over the time, doesn't progress, and it doesn't carry over from year to year. So this new annual leave close down clause in the award is largely the same. Probably the main surprise and the main part that members and employers have been panicking about is the prospect that they can no longer enforce the taking of leave without pay. So effectively that they may, and I'm going to say may again, have a scenario where they're required to pay a worker who doesn't have the sufficient time. There are options there. There are things that are going to happen beforehand. There's a whole bunch of if maybes, quid pro quos attached to it. It is an area of the award we previously haven't had any issues with, frankly, and so the need for the full bench to make a new term was a bit of a surprise because it's just not an area of the award we've seen. I've not had, been here for 11 years now, obviously. Some members have been through that time with me too. I can't recall too many questions about a worker being, frankly, miffed or upset or disputing this provision. Typically, it's been well understood and just a matter of fact. So, in essence, it could be the case that an employee may have to be paid for the time if they didn't have enough leave during a close down provision. However, I say that's a very big if, because what an employer might seek to do is simply have the worker work. Most of our members at that time of year are calling and asking about how am I going to manage my on-call roster. One thing you might be putting to employees, sooner rather than later now, is that if you have insufficient leave for this period, guess what? You've just put your hand up for being on call. Obviously, that's probably not going to be super applicable to apprentices because of the type of work they can and can't do, but you would likely find if someone doesn't have sufficient leave for the period and they're going to be around, they probably just got their hand put up for them for being an on-call roster if you have one. But let's not go to the pointy end straight away. Let's have a talk about the applicability and the process parts that are attached to this new close down provision. Let's be clear that if someone has an enterprise agreement that reflects the current term under the award, which does allow an employer to direct someone to take leave without pay, that remains in place. That's not affected by this model clause to the award because you have an enterprise agreement in place. When it comes to replacing that EBA, yes, it will be assessed against a new standard, this standard, and you may not be able to maintain that provision in your enterprise agreement going forward. At present, though, this won't apply to you. There are also questions or situational elements that can come up around the application of section 524C. We all knew and we all fell in love with that area of the Act. That's a provision of the Act in the COVID period when there were restrictions in place that prevented us from going to do the work that the business had, and that's where there's a stoppage of work. So for example, and very relevant and very much the comments of the full bench when inserting this provision into the award, they talked a lot about the practical application of these terms, and that if you're a subcontractor and you work on a large, or you're not in control of the site because a builder's in control of the site, that and they stop that site, well, then you may have a scenario in which you can stand the workers down under section 524 anyway. We don't have work for you because the builder where we work doesn't have it has stopped the work because they've closed the site down. There's a question sort of on the next point here around what does it mean to refuse an annual leave request because it's contingent on leave without pay. So the National Employment Standards of the Fair Work Act already have provisions in it that allow an employer to reasonably refuse, or at least not unreasonably refuse, annual leave requests. What I mean by saying it widens the scope is that an employer now, when getting a request for annual leave, will project forward to see how much leave that person's going to have at the end of the year and whether or not that's sufficient to cover their close down period. If the answer to that is no, you won't have enough leave to cover the close down period, then the employer will say, I'm not prepared to approve this leave now because you don't have enough leave for the close down period, which we will have at the end of the year. Simple as that. So it would then be a reasonable refusal. The employer would likely then go on to say, I am prepared to approve the annual leave period now if at the same time you submit a leave without pay request for that shortfall you will have. They will have that leave form and it will then be binding. The employer, if the worker wasn't prepared to do that, the employer might say, well, I'm only prepared to approve X period of annual leave so that you have a sufficient balance for the shutdown period. So I might only approve one of your 3 weeks requested because you won't have a sufficient balance at the end of the year. A question and a common scenario is going to be, what happens if I employ someone towards the end of the year and they don't want to take leave in advance, etc. What am I going to do there? There's still other ranges of options. If you do regular amounts of overtime, you might look at using toil so that the person has time off in lieu of overtime, balance there so that the person has enough to get them over some period of time. You will exhaust a range of other options. You'll exhaust a range of other options before you go down the last port of call, which would be, well, we're now going to have to pay you to do nothing, to go away, and I'd say that's a very outside possibility if you can have any other work that the person could be doing. I've indicated to a few members as well, having conversations on this area, that if you have to find work for someone to do because they're not going to take leave without pay, they don't want to leave in advance, there's not other options, it's highly likely that the work you might have for them might be otherwise not that most favourable work. So they might be the shed cleaning, the stockpiling, the stock taking, they might have a range of other duties that might entice them to next time around not be on to take leave without pay. It might be preferable to the dog's body work that they might have to be done at the same time. There's a good question around what about people using excessive annual leave to cover excessive sick leave periods outside of the 10-day period? Could we maybe decline using that? Anytime you're using someone's annual leave to cover sick leave balances, you would also have that conversation with the person about seeking their approval to do that first. But yes, the employer might say, well, we're going to hold on to a balance here so that you have enough for a close down period at the end of the year. And it would only be if the person wants to continue to be paid at that time, it again would be contingent on them applying for that leave without pay now so that they can continue to get paid. That's a good scenario. Good question. Thanks. There's a question around, is there an easy way to work out project annual leave, a calculator, for instance? Most payroll systems can do the projecting forward part, which I would say is easier than manual calculation of that. The manual calculation would look something like, and I apologize if you don't like numbers and maths scenarios, but the manual calculation of that would look something like, how many weeks is there before the end of the year? 2.93 multiplied by that number of weeks, that's the balance that the person is going to have, barring any leave without pay periods that affect that in between. So that's the best case scenario. If that's insufficient, then that's how you would work out it manually. I'd suggest that's not the easier way perhaps though, and that a payroll system can typically do a projecting forward for you. I'm not a payroll systems expert, sorry, so I couldn't say how that might be done in your system, but certainly you can look at projecting forward balances in most systems. Yes, it is the question here around the accrual rate for annual leave, 2.93 hours per 38-hour week is the way that annual leave accrues on a weekly basis. When it comes to apprentices and have them cleaning and doing things, apprentice supervision in the electrical space comes down to the electrical work largely. If someone's been inducted onto your site, inducted into your safety systems, and you have confidence in their competency to work safely, they don't need to be supervised for the purposes of shed cleaning, cleaning vans, stock taking, that sort of thing. That could be done with some level of general supervision. I dare say there's going to be some exceptions to that, for particularly for apprentices who might be under the age of 18 and or other safety type elements that you want to make sure that they're still general, and for all workers, frankly. If you've got anyone who might be in a vulnerable circumstance, you will want to still put your mind to the safety of someone working alone, which is something we always do from a safety perspective anyway. But that's the primary element that we will be looking at about their safety, not so much just as a product of them being an apprentice. There's a question around the daily rate for, I presume, for annual leave accruals. Look, the full way to calculate annual leave to its probably most practically shortest version is you take 152 and divide it by 1,976, and that gives you your per hour accrual of annual leave. If you want to then work that out on a daily basis, pro rata basis for a part-time employee or part day, you then multiply the number of hours by that. And it's a pretty horrific decimal number. It's got a 0.077 and a whole bunch of other stuff. If you want to work out the daily rate for annual leave accrual, you can do it that way. 152 divided by 1,976, that'll give you the per hour rate that it accrues, and then you can kind of do what you like with it from there. In terms of what work can a worker do, in this, if you have to get them to do work, can they do work outside of electrical work? Yeah, within their skill and competency, sure. Part of maintaining the premises could include things like mowing lawns, trimming hedges, cleaning vans is not electrical work, and that's well established. Stock take is not electrical work, but certainly helps someone like an apprentice in terms of a training outcome, develop their electrical knowledge and experience, so that's at least linked a little bit to their training outcomes. This question around if there's a formal letter for leave without pay, I suggest that all employers should have a leave type of form, and that leave form allows a worker, whether it's electronic or a Word document, electronic as in within your payroll system, or electronic within a Word format or a physical form, that all employers ought to be using some sort of leave form for their records. In terms of what might I have as a minimum, it would be acceptable for the worker to submit an email to you that says, I wish to take leave without pay for this period, and the employer files that with the employee's time and wages records. That's a good absolute bare minimum, but I would suggest a short form, and we do have an example of a leave form if you're looking for one, can be utilised there to capture that the person wants to take leave without pay. Thanks for those questions. Where do we get to with the slides? I think we covered largely most of those elements around what might happen if the employee had a shortfall. Annual leave in advance, what I would say about annual leave in advance is that the award is helpful in this area, provided you follow the rules. The rules are get the request for annual leave in advance in writing, because that gives you the ability to withhold on termination if the person hasn't worked back that shortfall without it, with it being lawful, basically. And that's the way you want those. You can't do a sick leave in advance type scenario, but the award does allow for leave in advance with the ability for the employer to withhold if the worker hasn't recovered or recredited, if you like, that amount from their final pay. So that is what I would talk about with respect to annual leave in advance. Sure, yeah, we can. The leave form is available through our workplace relations team, so that's not a problem. We can get that around. That's a good question about leave without pay in general terms, about how accruals work. For an award-based employee, so outside of an enterprise agreement, particularly say an ETU enterprise agreement, so an award-based employee taking leave without pay, they do not accrue annual leave or sick leave during that time. So there's no 2.923 or 2.93 hours of leave accrued for that person because they haven't got service during that period. They're not actually serving any period of time. Paid annual leave, paid sick leave, paid public holiday entitlements, they all count as service. And because they count as service, we continue to, and therefore time worked, we continue to accrue annual leave and sick leave during that time. So they won't, if someone takes leave without pay, even if it was for 1 day, for example, they're not entitled to the full 2.923 hours of leave there to accrue. Many employers might go, well, that's too hard in my payroll system to change for the purposes of one leave without pay day here and there, but is within the scope for the employer to say, well, it's a leave without pay, so no accrual of annual leave or sick leave in that scenario. Just a bit of an admin question about how this material then comes to members after the session next week, once our marketing team has been able to sort of put together the Q&As from your questions here, which there's a lot, so there'll be some time spent with the Q&As and the recording. Any other additional material, we're looking at sending the wages summaries out to all the participants who've registered here as well, for those who are members. And we'll include the leave form. I'll provide the leave form to marketing as well. They'll provide that next week following this, and you can be able to go and check out the material after the fact. All right, in terms of model clauses, did I have more points? I might just go back up to that just in case there's more questions there. I have a question around perhaps a more broad question around paid hours, reducing that from an employee requesting to reduce from 38 to 34. It's a difficult question to answer without sort of going into the background a little bit more of it, because a request to go from 38 to 34 would make the person a part-time employee. And so the first question from me would be, if we were talking about that on the phone, would be, is this person requesting to be part-time? If the answer is yes, well, that's a contractual change to their engagement. I wouldn't see how that sort of relates to the leave without pay element, or to reducing the amount of leave without pay. That's separate. A worker could regularly take leave without pay, applying for, say, 4 hours a week, if that's something that could happen. I mean, sounds like it's very contingent on a range of elements, so I'm not sure I can give you a great answer on that, I'm afraid, Linda. Josh, in terms of the new wages summaries, those will be available early next week. The Commission is seeking to ratify the wages as at today in terms of getting their feedback. So I expect they will have done so by Monday or Tuesday, and we'll be getting them out to you as quickly as we can after that. Thanks, Josh. In terms of that previous question around the leave without pay, reducing that to 34, look, I really want to talk, and the follow-up information has been just to reduce or to cover the close down period. I think we might need to talk about that sort of a scenario separately, Linda. I would like to unpack that a little bit more to see what you're proposing and how that might work. I'm reluctant to think that might be a solution, but I might just be missing some parts about the scenario which we could talk about. An excellent question around leaving the release of this information so late in the year. It might be a little bit surprising. No, it was actually early this year. The Commission usually doesn't make its decision until basically today, historically, and then we're in this mad flurry of trying to get this stuff done, and most of my calls are panicking members, where are the wage sheets? So the Commission this year actually brought it forward 2 weeks. So it was the beginning of June that they did the wages, the national wage decision, so that we would get through this 2-week period and then still have best part of 2 weeks to implement it. So yeah, they have heard a little bit on that front of, well, we need these wages as soon as we can. And so we've got a 2-week window this time, as opposed to a potentially 2-day window. I appreciate that's probably not as much as some would like, but we are a little bit earlier than we've historically have been. So that's a little bit of good news. The question, Anthony, thanks, about the last line of that slide. Yeah, if you've exhausted all other possibilities, or if you don't have an enterprise agreement, or you're not a building site where the builder has shut down the site, they are perhaps a new employee, or they don't have toil, they don't have RDOs, they're not willing to take leave in advance, that's where you would get to the point where an employer goes, I'm going to need to pay this person to sit at home during our this shutdown period, or I am going to find work for them to do because they have elected not to take a leave without pay. I guess an element or a statement to make: a worker is not obligated to take leave without pay is the fundamental upshot of the change to this clause, which is different from what it was. A worker, I'll repeat that, is not obligated to take leave without pay in a closed down period any longer under this model term. There's a question, again, a sort of a broad question around leave without pay, and I'll leave aside closed down periods and model terms and all that sort of stuff, just to talk about leave without pay in general scenario. There isn't a statutory entitlement as such to leave without pay in just any context. There are unpaid carers leave provisions, which is obviously a form of leave without pay, and there are situations in which an employer would be compelled to approve leave without pay. So if a worker broke their leg, required a 3-month rehabilitation, and didn't have enough paid leave entitlements to cover that, an employer wouldn't be able to dismiss that person lawfully for a short-term injury or illness, or due to an impairment as a matter of course. They would need to approve a period of leave without pay there in a scenario. If a worker came to an employer with a request, look, I want 3 weeks of leave without pay because I want to climb Machu Picchu and have this life-changing, altering experience, can I have some time off, please? The employer is not obligated to approve that. No, that's an entirely a scenario where an employer can go, no, I'm not prepared to approve that, and frankly, it's not. It's happened sometimes where an employer has said, if you leave your employment and don't take this leave anyway, that places your employment in jeopardy, and we may ask you why your employment shouldn't come to an end. So there's different scenarios in which leave without pay can be requested, and so we would really need to look at where that comes from before we made a call about whether we were obligated to approve it or not. A good question here around paying out of leave, sort of a broad question as well, and applies to other areas of the award. In this scenario, workers are requesting that they pay out leave and continue working. There are very strict rules in the award about the cashing out of annual leave, and annual leave only. Sick leave, you cannot cash out under the award, sick leave at all. Breach the award, potential penalties, most likely just the impact of the person having an entitlement to paid time off, which you've already paid out. So you'll feel doubly miffed by having done so. So paying out annual leave is allowable under the award. The strict rules that apply are the person must have a 4-week balance after the cashing out has occurred, and the maximum period that they can cash out in 12 months is 2 weeks. So if someone wants to come to you and cash out leave and they want to cash out 2 weeks, they need to have 6 weeks of leave basically at that time. You cannot go below the 4-week mark, even by agreement. Doesn't matter, don't ask. It doesn't matter that they might agree to it. You can't go below that. They can't take more than that, and that's annual leave. There's a general question around sick leave, and its accrual. Is it continual like annual leave, or does it cap? Annual leave and sick leave will continue to accrue. Balances will be carried forward. There is no cap on the amount that can accrue. There is no cap on the amount that can be accessed. So if I've been an employee for an employer for 5 years, I've never taken a day of sick leave. I have 10 days by 5, so 50 days total, and I break both my legs in a serious car accident, touch wood, hopefully not, please, and I need to take all 50 days, the employer will pay me 50 days of sick leave. There's no cap there for personal/carers leave. This question around cashing out of RDOs. We're jumping all over the award now. This is fun. It's like a barrage of questions. Thank you. Cashing out of RDOs that are accumulated. The award requires that RDOs are taken when they fall due. It does allow for the substitution of RDOs. It does allow for that to be taken in the following work cycle, so in the next 20 days. I know that practically speaking, a lot of employers might simply just bank them. That's strictly not compliant or consistent with the award provisions. When it comes to cashing out of annual leaves, yeah, you could do that. You could mutually agree there. It's not provided for in the award. It also doesn't come with the same sort of restrictions and strict rules that annual leave does. And the benefit to the employees that they still get that paid out. It's at its ordinary time. The risk though is that the employee says, well, I had to work on my substitute day. I never got it off. I never got the paid day off, which is what the RDO system is. The employer can risk claims still that, and I haven't had any, I must be clear, that the employee is entitled to some penalty or loading for the day that they did work that they ultimately didn't get off because you then went and cashed it out. So I would suggest that cashing out of RDOs is well something you can do. Just the banking of them, frankly, is probably something not something I would do. You might like to utilize a short individual flexibility agreement to give you the ability to bank RDOs. That's a thing. That's an allowable flexibility term that you can do, and you can set some provisions in there around that. That's fine. But my first suggestion to you would be to make sure you're taking the RDOs as they fall due. There's a question around apprentices and having an apprentice take leave without pay during the year, there's not a problem there unless it's a substantial and significant amount of leave. If I'm the apprentice who's broken my legs and now I need 6 months off for recovery, I'd want to get onto my local state training department to talk about a suspension of the training contract in that scenario, because it will likely affect the length of time that it's going to be on their apprenticeship. If it's a shorter period than that, then typically the training departments will go, look, let's see how it fleshes out at the end, whether they're ready or not, whether we need an extension to their training contract or not, because it's not uncommon for apprentices to be signed off early from their training contracts. And apprentices are governed by training contracts. There are conditions of employment dealt with under the electrical award, so that's there's not a specific apprenticeship award, as there used to be in Queensland, particularly an order for apprentices and trainees. It all just falls now within the electrical award. Good question about using banking RDOs and what might we bank them for? Yeah, you could absolutely bank RDOs towards a shutdown period at the end of the year so that they have enough for that period. So that is a perfect way to use banking of RDOs, not a problem. And in terms of, well, that's different to what you said before, Jordan, about making sure people take them as they have them. Yeah, it is. Let's do that under an IFA, individual flexibility agreement, to give you the ability to bank without risks around someone not getting to use their RDO at that time. There's a question here around RDO, not found in the RDO term for accrual in the award. Yeah, it's there. It's at clause 12.13, I think, if we're having a look. Let's check my memory. I'll just grab it up in the background here. It won't be 12.13, it'll be 13.8, sorry. 13.13 is shift allowances, shift loadings. So yeah, 13.8 deals with the provisions. What you might be looking for about the 0.4 or 0.6 or whatever is, no, it doesn't express it in those terms. Some EBAs will go the working day, particularly if they're an ETU EBA, the working day is a 7.2 hour day because they operate under a 36-hour week typically, a 7.2 hour day, and then 0.8 of an hour is banked towards an RDO, and they typically work a 9-day cycle often there. You're right to say that the award doesn't say, 0.6 or 0.4 or 0.8 or anything like that. It's left for us to work that out. So an RDO system works by sort of working back from that 20th day of the work cycle as a paid day off to being 19 days of if you take if it's a paid day off is 7.6 hours, for example, and it strictly is under an RDO system, a 7.6 hour scenario. 7.6 divided by 19, because I need to work the number of days in order to get that paid day off. So 7.6 divided by 19 will give me 0.4. And so 0.4 is the time each day that I need to work. So a normal working day is 7.6 hours, 7 hours and 36 minutes. Then the worker is going to work an additional 0.4. 0.4 is 24 minutes. So that gets you to your 8 hours of work, not excluding the unpaid lunch break. So that's going to get you to 24 minutes of work each day. Over 19 days buys you that paid day off on the 20th day of the work cycle. So hopefully that helps with that. All right, what a whirlwind of questions all over the award. Thank you. That's pretty much what I was planning on talking about and more. So thank you for the more. That wasn't sarcasm, that was thank you. A lot of members get a lot of help out of those sorts of questions. They've been wondering them, mulling them over in their own minds. So thank you for all of your questions. It's it's great to have engaged participants. Sometimes I feel like I'm talking to my computer and then maybe I've gone mad because nobody's been interested. But it's definitely thank you for your questions, and they have kept me on my toes, if nothing else. Hopefully you got something out of them as well. Just on the screen here as well, if we're having issues next week with the 403 error and yada yada, the MSS team will be able to, or we'll give them the wages summaries there. They'll be able to, if you just want them, MSS team will be able to send them directly to you, or shoot us an email at the WR email address and we will send them out there. I'm trying to get as many different ways at the moment that I can basically spam them out to you, and if you get them multiple times, I'm sorry, perhaps, but I just want to make sure we can get them out to you as quickly and easily as possible, given that I am expecting we might have some website issues, or if we're not getting website issues, that you just got them as quickly as you could anyway. I know members regularly ask for them to be sent to them. We're just not really able to usually, unless you specifically ask, send them to you as a spam thing. Spam laws literally come into play. So as I said earlier, the marketing team's going to send around a recording of this session. They're going to send around the things that I've mentioned. I'll include the IFA banking of RDOs as well. You're welcome to use that. You might like that, the leave form we talked about. I'll include that, and the wages summaries. If things go to my expectations around timing, we will be able to include those as well for members who've registered. So thank you very much for coming along. Hopefully that wasn't too all over the shop for my answers on some of the different topics, and you were able, and I was clear on those, and they were helpful. But thank you for coming along. I know it's a busy time of year, so thanks for making the time to come along and hear this, and hopefully we can get this information out to you so you can get into your payroll systems as quickly and easily as possible. I haven't had any more questions coming through, so maybe I've exhausted everyone else on their question front, but thanks for coming along. I'll wrap the session up. If you've got any other questions that you didn't ask there, they don't have to be wage-related questions that come to that WR email address. Myself and Anne will both get those, and we can start to work through some of those other questions that might crop up, or you might wake up in a cold sweat if you thought of something that you didn't ask now. 2 a.m., we'll get to it in the morning. On Monday, though, I probably won't be waiting by my email at 2 a.m. Something will have gone wrong. So thanks for coming along. Best of luck. Happy Friday. Thanks, and we'll talk to you again soon. Thanks. Bye.